Hello, everyone, and welcome to today's webinar on domestic violence awareness. My name is Ana Santiago, Resident Services Administrator. Having a protection order does not guarantee your safety. Sometimes asking for a protection order can make the violence worse. Domestic violence advocates can help you understand the warning signs that can increase your risk. To decide if getting a protection order is a good legal option for you, talk to a lawyer. Today, that's what we're doing. Alexandria Ruden, supervising attorney in Legal Aid's Family Law Practice Group, is the inaugural recipient of an award named in her honor, the Ruden Award for Exception Services in the field of family violence prevention, presented by Ohio's Office of Criminal Justice Services. Alexandria has helped more than 5,000 survivors of violence since beginning her legal career over 40 years ago. Because of her work on boards and committees statewide, she has brought domestic violence to the forefront, greatly impacting the legal system. She continues to represent clients in their domestic violence cases, but she also travels around the state and the country educating and training domestic violence advocates, judges, lawyers, probation magistrates, law enforcement, and others on laws surrounding domestic violence issues, types of protection orders, and more. Now, please join me in welcoming Ms. Ruden.
Good morning.
Good morning.
I'm Alexandria Ruden. I work at the Legal Aid Society of Cleveland, where I am a supervising attorney. So other than representation of public policy, I also mentor our newer lawyers who are learning to do domestic violence work. So for today, I am going to talk a little bit about what domestic violence is, what domestic violence protection orders, restraining orders, and then end with talking a little bit about how to. So I'll give you my disclaimers. I know that both sexes can be abused. I speak, though, in terms of male-female because it's easier than talking in terms of they. So for this presentation, the victim or survivor is going to be the female and the abuser is the male. But I know over time that is not the extent of it. Both men and women can be abused. Now, I will also speak in terms of survivor victim, and I will use those interchangeably. Why? Because many clients consider themselves victims until they're ready, and they then call themselves a survivor. Some want to be known only as a survivor. Now, what's so interesting is the new terms around the country are the person who caused the harm, which would be the perpetrator, versus the person who suffered the harm, being the victim. Now, some of what I say may be confusing, but since I'm talking about the law, I'm here only as the messenger. Please ask questions. So I start with what are some of the myths, because these myths permeate everything that I know about the legal system. Domestic violence happens in low-income communities. It's a private family matter. It's about impulse control and anger management. It's caused by drugs or alcohol. None of these are true. You get rid of that impulse, you get rid of the drugs or alcohol or stress, and you have a sober abuser. It has always been considered a family or household member, but in the 60s, it became more visible. Hence why we now have a domestic violence statute, because the way to make society understand what we're talking about, we needed to give it a name, and it was domestic violence. And it was in 1975 that then Attorney General William Brown convened a task force to determine whether in Ohio, domestic violence was epidemic. And like everywhere else in the country, it was. So things transitioned from only addressing strangers and looking at DV as a family matter to looking at domestic violence looking at domestic violence as a societal problem. It does not happen in low-income communities exclusively. It runs the gamut. It traverses all socioeconomic levels and ethnicities, etc. Now, the other myth, victims provoke the violence. And that is not true. I can provoke my husband, let's say, but if my husband then acts upon that by hitting me, that's the piece that's not acceptable. And what we hear from courts all the time. If it really was bad, if this woman or this man was really abused, then they would leave, they would not return, they would not stay with their abuser. And they either it's not that bad, they're exaggerating, or it didn't take place. Additionally, another myth, a true victim is. Okay, what is a true victim? If somebody is sitting there cowering, learned helplessness, oh, society says that's a true victim. The legal system says that's a true victim. But if a victim then has agency and then becomes assertive, well, guess what? You can't be a true victim. And domestic violence doesn't impact children. It absolutely does. The studies are replete with information regarding children who are directly impacted and those that witness domestic violence. So, what is domestic violence? It is an incident or a pattern. It's mostly a pattern of controlling, coercive controlling behavior, sexual violence, stalking, emotional, financial, physical, psychological, even digital and online. But the objective of domestic violence, unlike any other crime, is to establish control and maintain it over an intimate partner. So, what DV is not? It's not random. It just doesn't happen. It is against somebody, unfortunately, you love or you care about. It's not mutual. And it is not isolated. It is a pattern. It doesn't always have to be a pattern of physical abuse, but it is a pattern of behavior. So it matters because we need to know what the legal definition is, the behavioral definition, and we also need to know because the physical assaults don't occur all the time. What's part of it is the coercive controlling behavior, the emotional impact and abuse. So what we found is everything interacts that creates that pattern. So we also know that we have to look at lethality when we look at domestic violence, understanding that each thing on this PowerPoint shows what the lethality factors are, the history, the frequency, the severity, stalking, threats to kill, suicide versus homicide. The two most dangerous and high risk lethality factors are if there is strangulation or firearms. So we have to look for that. And then we need to know that there are different risks for a survivor who wants to go to court. The system looks in terms of what is significant danger. Victim loses life. You see physical bruises, the actual physical impact of domestic violence. Where the victim concentrates when she goes into the system or he goes into the system on, oh my God, I could lose custody of my kids. I could lose my job. What is the impact if I have to move them from school? The shame of it all. So there are different views of risk for both the criminal justice and civil justice system and the victim. And now we go into who an abuser is. They think they're better than others. They use anger to control. They seek to project an image of self-importance. They don't usually express emotion. They avoid responsibility. But most importantly, abusers lie more convincingly than a victim survivor tells the truth, which is unfortunate. Victim characteristics, they're isolated. They don't trust the system. They don't trust law enforcement. They have a hard time trusting anybody, even those that want to help them. They also, where the abuser minimizes domestic violence, that victim does the same thing. The victim believes those myths that I talked about earlier. The victim feels shame, embarrassment, and a lot of self-blame. So then we look at how these parties look to the court when they get to court. You have a victim survivor who can't present evidence because they're afraid, they've had cognitive impairment, brain injury from having been abused, they suffer trauma, they demonstrate inappropriate affect, no affect, or anger. They appear unfocused. And when they act like that, the system thinks they're lying. Then the abuser appears vulnerable to the system, attempts to present as the true victim, minimizes. If she hadn't done that, then I wouldn't have had to. I was only trying to restrain her. But as I said earlier, that perpetrator, that abuser lies more convincingly than the victim tells the truth. So it's time to reframe the paradigm. What we've seen over all these years is society does measure harm and by the injury suffered. So if I see bruises, if a court sees bruises, we know that's serious injury. But that push, that hit, that threat, what does that mean? We normalize, unfortunately, the non-serious injury. So it's now time to look at a continuous nature of domestic violence with coercive controlling behavior. It's not a one-off. So I talk a little bit about a coercive behavior. I'll give you the best example. Here, two parties are married. He makes a demand. You're ugly. You're too fat. You better start losing weight or I'm going to leave you. And that's the threat. I'm going to leave you. I'm going to tell people about you. Or I, as the abuser, will commit domestic violence. So then the victim has to comply. So what does the victim do? She doesn't want her husband to leave. So she maintains an acceptable weight. Then he monitors that by surveilling food, putting a lock on the refrigerator door, telling her when she can eat, when she can do certain things, how much she needs to exercise. And then the way he enforces that is he compares her to a woman on the street, the neighbor, anybody he sees. And then her response is mixed. It's complicated. She goes back and forth between apologizing and then being angry. And as she complies or she resists, the violence and the control also increases. So it's almost like a no-win. So now we move into protection orders. And all I can say is one error and everything falls apart. Everybody needs to be on the same page. The judge, the magistrate, the attorney, the prosecutor, the criminal court, the issuing court would be a domestic relations court, the sheriff's department, the clerk, police, the advocates. We need to work in lockstep or something falls apart. And often we don't work in lockstep and something does fall apart. So we look at protection orders and intimate partner violence. Survivors are looking for relief, often at the time of separation. However, the time of separation is a very high-risk time for further abuse and homicide. Some survivors will access civil orders just to avoid the criminal system. They want to be left alone. They want to be left alone, but they also don't want that other person charged. So this criminal system looks too daunting for them. Additionally, what victims want is they want fairy dust. The system has to use the law, but the victim just wants the violence to stop. And they'll do that any way they can. But research does suggest that protection orders are used after victims usually try self-help remedies to stop that if they report and then no one does anything, or sometimes the law enforcement, when they report, does do something. But that's when they seek these protection orders, when the remedies they feel work don't actually work. So, effectiveness of protection orders. Studies show that abused women who have got a protection order and reported significantly lower levels of violence during the subsequent 18 months after they get that protection order. One can conclude that the justice system and the context with that system lead to the reduction of violence. Additionally, another studies found that protective orders were not violated for half of victims for a 6-month period that are ex parte orders or the full hearing orders. So victims also report they were less fearful of harm during that period of time. But just because you can get a protection order doesn't mean you should. For some, a protection order may not be the safe or logical option for a specific victim. There are many things involved in seeking these protection orders. One, are you eligible to seek a protection order? That means, do the acts of domestic violence as defined in statute apply to you? If not, then getting a protection order puts you at greater risk, because if you don't get it, because the statute, what you're arguing and what the statute says are different, then that abuser is going to be more empowered. And we don't that we don't want. But once a determination is made that a survivor may qualify, it still may not be the best option. And when push comes to shove, you do not tell a victim, just get a civil protection order or just get a restraining order. And there is a difference between the two, and I'll talk about that later. But before referring somebody, you have to consider other aspects. And I mean, before you refer somebody to get a protection order, and that is, we know that victims file pro se, that the studies out of Cuyahoga County Domestic Relations Court, which is where you get civil protection orders, says in over 90% of cases, victims come into the court pro se. That means without legal representation. So these victims come in blind. They don't know how protection orders will affect them or how they affect the other legal issues a victim may have. Victims will have to face their respondents if the respondents who are the abusers show up. Are they emotionally ready to face their abuser? Maybe yes, maybe no. That's a question that needs to be answered. And victim readiness. Do they really want the order? Do they want everything that may follow from going to court, getting that order, having to deal with him, either having him out of the home where they really don't want that, they want the violence to stop, or doing nothing? So that has to be discussed for victims. And filing could be harmful. And what is really important is to look at what are the intimate issues that may face. One, it's a civil matter, a protection order. Victim safety can be minimized. General crime victims can rely on civil protection orders, but may not. Plus, there are different responses across the different jurisdictions. I'll give you an example. You have somebody who's in hiding. She's being told she should get a protection order. Once she does that, he's going to know where she is. If they have kids, she may have to give him access to the children, because in a protection order, one of the remedies is parenting time. Sometimes victims don't know that. Let's say there are other actions pending. Let's say there are juvenile court actions. And during the time that the victim has to talk about her case for a civil protection order, the husband's lawyer will say, were you drunk when this happened? And she says, oh yeah, we were both drinking, to be honest. And then he gets a transcript of what she said, goes to juvenile court and says, see, she was a drunk. So anything that a victim says in a civil protection order can be used against them in other actions, legal actions. So again, a lawyer can help them make those decisions. If they go in pro se, they can't be given advice. So Ohio's protection order system, the reason you're here, the first question many ask is, why do we even consider a protection order? The second question always asked is, why do we need so many? Ohio has 6 separate state protection orders, plus a no contact order, and 2 of which may have federal implications. So the purpose of a protection order is to prevent violence before it happens. There's an act of violence, you get a protection order, and you're preventing future violence before it happens. Why so many? Because each protection order is designed with a different focus in mind. Now, this is confusing, but there are two types of remedies. There are civil or criminal. Now I'm talking about protection orders. So there are the grant of any one of several types of protection orders, and we talked about them. And there are several types of protection orders. So there are two types of domestic violence protection orders. There's the civil protection order, which is going to be our focus for domestic violence. And then there is a TPO, which means if somebody gets charged with a crime of domestic violence, an offense of violence, or other crimes in the criminal code between family or household members, they can get what's called a temporary protection order while that criminal case is pending. Or they can go and get a civil protection order. Or they could get both, but they should talk to a lawyer if there's a criminal case pending and they try to get a civil, because anything they say in the civil can be used against them in the criminal case. There are dating protection orders. Then we have two types of stalking protection orders: the criminal stalking protection order for acts of stalking, and for non-family or household members, and the civil stalking protection orders, or the civil sexual oriented offense protection orders, and then juvenile protection orders. I understand this is very confusing. So when we're looking at protection orders, we need to, are they civil or criminal orders? Does it depend on a specific court? Municipal courts grant the criminal orders, which are the CRPO and the TPO, if they are misdemeanors. If, however, they are bound over as felonies or charged as felonies, then you go to the common pleas court and you can still get a TPO or a CRPO. Remember, the TPO is family or household members. The CRPO is non-family or household members. The common pleas court is also where you would get a civil stalking protection order or a civil sexually oriented offense protection order. You go to domestic relations court to get a domestic violence civil protection order or a dating violence protection order. And you go to juvenile court if the respondent, that means the person who causes the harm, is under 18. So some depend on the relationship between the parties, one depends on the age of the offender, and some just depend on the nature of the crime. The one that depends on the relationship are the DV protection orders, the DV-CPO or the DV-TPO. One depends on the age of the offender. That's the juvenile protection order. And the rest depend on the nature of the crime. Those are the civil stalking, the criminal stalking, or the sexually oriented offense protection order. Then we move into all protection orders. And I will say, to make it simple, all protection orders come out of the domestic violence protection order statutes. They were enacted in 1979. And since then, in 1992, we got the criminal protection orders, and we got what's called stalking. In 1998, we got the civil stalking protection orders. In 2010, we got the juvenile protection orders. And in 2018, we got the dating violence protection orders. All civil protection orders have stay away provisions. All have similar case analysis. All are very similar as written. All address certain criminal behaviors. And all are in addition to, but not in lieu of, any other civil or criminal remedy. To understand protection orders, we need to know which court, as I told you how confusing that is. The petitions are different. Who may file is different. The acts are different. The procedures are pretty much the same. They all have ex parte orders, meaning That victim goes in, talks to a magistrate or a judge, tells their story. There's nobody at that hearing, no defendant, no respondent, no offender. Then there is a full hearing order set between 7 and 10 court days after. And that one, the offender has the right to be present and tell their story. Civil DV protection orders can be granted by consent. They stay in effect for a period of time, but not to exceed 5 years. And there are many different remedies depending on the protection order. So for purposes of domestic violence and the Domestic Violence Civil Protection Order statute, you must be a family or household member. There are certain people who reside or who have resided together. That's spouses, former spouses, people who are related by blood or marriage. Those people or children can get protection orders. Understand they will have had to reside or have resided with the offender. It also includes people who have never lived together, never resided together, but who have a child in common. It also includes foster parents. It also includes persons living as spouses. This is that degree of commitment. We've cohabited, we've lived together, we share different financial or familial responsibilities, and we have lived together within 5 years prior to the act of violence. Those people are covered as well. These are atypical same-sex couples, step-parents, stepchildren. All those two and foster parents are covered under the domestic violence statute. Certain dating relationships are also covered. And then I go into what those sharing of familial or financial responsibilities are and consortium. Those can be atypical family or household members as well. Then we move into what acts. So anyway, the most important takeaway of that is you have to be a family or household member. Then we move into the acts. Attempting to cause or recklessly causing bodily injury, somebody who threatens another, somebody who commits an act of stalking, aggravated trespass, committing an act with respect to a child that would result in that child being physically or sexually abused or endangered, or committing any one of 29 sexually oriented offenses. When is stalking domestic violence? When it occurs against one family or household member. So, as I said, if you're a family or household member and there are acts of stalking, you go into domestic relations court. If you are a non-family or household member, or you're interested in forum shopping, then you get a civil stalking protection order in common pleas court. The definition of stalking is a pattern of conduct knowingly causing one person to believe the other will cause physical harm or causes mental distress. And then the last one, no person through the use of an electronic method of transferring information, actually talks about social media and what you cannot do through a computer or social media. I gave you the definition of aggravated trespass. You cause physical harm on the property of another. And the sexually oriented offenses could be rape, gross sexual imposition, battery, importuning, pandering, and other crimes set forth in 2950.01. And there are 29 of them that applies. Again, domestic violence towards a child. So here's what we know. Child abuse is domestic violence. Parental discipline is legal. Corporal punishment is legal. So then the question needs to be asked, when does parental discipline exceed which is proper and reasonable? And if you're charged with domestic violence for abusing, and I'm putting that in quotes, a child, there is an affirmative defense of no, it was reasonable parental discipline. And then a court needs to consider the age of the child, the injury suffered by the child. How was the parent? Was the parent screaming and yelling and threatening, or was the parent exercising parental discipline? And what did the parent do before they chose to hit their child? Did they talk to their child? Did they put their child in timeout? Any of those things. So courts have a a big job to consider whether there was DV towards a child. I haven't mentioned that there's also domestic violence where the children witness the violence between their parents. They too are impacted by that violence between their parents, even though not directly abused. So these are the remedies under the domestic violence protection order. You can restrain somebody from abusing you. You can order them to vacate the home or stay out of the home. You can give them exclusive use of a resident. You can require the respondent from refraining to enter their school, business, place of employment, or having any contact. You can temporarily allocate parental rights and responsibilities if another court is not determining it. So if you go in and nobody's been to juvenile court and you have children together and you're filing against the father of your child or the mother of your child, and there's nothing pending in juvenile, the court can temporarily allocate parental rights and responsibilities. The court can require a respondent to maintain support, require counseling. If you have pets together and you own the pet, then your companion animal could be removed from the abuser, retrieved if it was owned or possessed by you. There's something called wireless transfer. If you're on a family plan, by law, the provider of that family plan can separate the plan so you can get your number and you don't have to be tethered to that family plan where that abuser would know. So you get your own number, but you also get your own bill and you'd have to pay for it. It also grants other relief, such as apportioning furniture, permitting use of a car, and under that, prohibiting somebody from having firearms. If a protection order, a civil protection order, is violated, it has there are two options. One, a motion to show cause back in domestic court. You file something that just says that this person violated the order. The court, usually a civil court, would normally say, just don't violate it again. Or as a condition for you not going to jail, you have to do A, B, and C. It could also be the basis of a criminal prosecution under the criminal code, or both. Any civil protection order is enforceable statewide, and any protection order issued from anywhere in the country is accorded full faith and credit in Ohio, so it has to be enforced. Law enforcement agencies by statute are obligated to enforce civil protection orders, including removing the respondent from the premises. Now, this may be a time to tell you the difference between a protection order and a restraining order. Even though sometimes the words are used interchangeably, when we talk about a protection order, we talk about something police may enforce. It's granted independent of any other action. A restraining order, for our purposes in the state of Ohio, is a temporary injunction that one puts on for different court purposes. Like in juvenile court, it's sort of a stay away order. When the juvenile case is over, it goes away. Or in a domestic relations case, while the case is pending, the parties stay away from each other. One is enjoined from abusing the other, and those go away by operation of law. They just disappear and they melt away when the case is over. If there's any questions, we'll have some time to talk about it. The takeaways for a DV protection order: you must have a family or household member relationship. Some acts can be considered if there's a juvenile, but anything juvenile has to be issued and enforced in juvenile court. Then we move into a civil stalking protection order. As I said, since everything comes from the DV protection order, there are many similarities. The contents of the petition are the same. The burden of proof is the same, which is a preponderance. Is it more likely than not that this act took place? You can get requests for ex parte orders. You have full hearing orders. If these orders can be violated, as I told you a little bit ago about DV protection orders, you adhere to the same rules of procedures in all civil protection order proceedings. A victim survivor is entitled to a victim advocate. For protection order purposes, the victim survivor is the petitioner, and the offender is going to be called the respondent. There's no cost associated with getting a civil protection order. And the case law from DV is used for stalking, is used for juvenile, is used for dating. The case law uses the same analysis, and each protection order, when you look at case law, this was never addressed in the civil stalking, but I'll go to the DV protection or look at the case there, and it was addressed. And because they are the same, there's no problem. And all courts consider the same case law. More similarities. All protection orders can be renewed. They can't be waived by invitation of the petitioner. And what I mean by that is, if a petitioner gets a protection order and then she asks him to come back to the home, it doesn't dismiss the protection order. It stays in place, and the petitioner cannot be charged for violating it. The order is against that respondent, the subject of the order, not the petitioner, the recipient of the order. All protection orders, none of them allow for mutual protection orders, which means a petitioner goes in, asks for a protection order, gets it. At the full hearing, he shows and he decides he's going to agree to it. But he says, I want her to stay away from me. The court can't issue a protection order against both. If that offender wants a protection order, he has to file, or she has to file, her own specific order. If a protection order is denied at the ex parte level, and not granted by a court, or a victim, for whatever reason, doesn't want to file it as an ex parte order, it shall still be set for a full hearing. That means a court can say, I'm denying this because I don't think you proved your case. It doesn't matter. It's still going to be set for a full hearing. The differences are, again, between civil protection orders, civil stalking, are the courts. If it's DV, it's domestic relations court. If it's civil stalking, it is in the common pleas court. For civil stalking, it is an act of stalking, the same act is defined as I told you earlier, or it is any one of the sexually oriented offenses or aggravated trespass. You can have an ex parte hearing like you would in DV, but instead of it being within 7 or 10 days, it is 10 days. These protection orders cannot be granted by consent, meaning a respondent can't agree to it, and they can't be modified or terminated. But the DV protection orders have much broader remedies, which means if somebody wants to get a protection order, they are available to get them in DR court, but they choose to go to common pleas and get a civil stalking order. They only have the ability to get stay away remedies. They can't have custody, parenting, they can't divide property, etc. The one thing the civil stalking order has is the ability to have electronic monitoring. So how do you establish a case? You look a day before and after the stalking began. To show mental distress, which again, stalking is the pattern of conduct that causes one to believe the other will cause them physical harm or causes mental distress. You look at, has the victim moved, changed jobs, slept with a bat, now has a guard, has a blink or a ring box there, bought pepper spray, bought a weapon. That's how you prove mental distress. For civil sexually oriented offenses as well, you don't need a conviction. You don't need charges. You just have to prove the elements of the behavior. And I know this is somewhat confusing. It's confusing even for judges, lawyers, and police. But both civil protection orders and civil stalking protection orders and civil sexually oriented offense protection orders, they're all civil. You don't need convictions or charges. You don't need a family or household member relationship. If there is one, it is between the petitioner and the family members of the petitioner, meaning that if you go in to get a civil stalking protection order, you get it for yourself and you want to put your family on it. It's your family. It isn't anything to do with the respondent. So why would you get a DVCPO rather than a civil stalking? If you're married, the advice a lawyer would give you is you go into domestic relations court and get a DV because the remedies are broader, especially if they're children. A civil stalking protection order is a stay away order. Additionally, to get a civil stalking, you would need a pattern of behavior. In a DV, you have normally that pattern of behavior, but you just have to prove an act or a threat. The main takeaways for civil stalking is the relationship doesn't matter and the respondent must be over the age of 18. Then, as I'm going, I want to go quickly so we have 15 minutes for questions. Then we have dating protection orders. It's between an individual of any age who has had a relationship with a respondent who's over 18. It does not mean, and it does not include that casual acquaintanceship or an ordinary business fraternization. So for a dating relationship, what I'm saying is there has to be some degree of commitment. And they must have been in that relationship within 12 months preceding the conduct in question. The dating protection order is very similar to the others, but if you're going in on a dating protection order, you also have to include the facts upon which the court may conclude there's a dating relationship. The nature of the relationship, the term, the length. Did the parties believe they were in a dating relationship? And because a dating relationship, as defined, is a relationship of an intimate or romantic nature, you see the degree of commitment. There's only some relief that's available. You don't get exclusive possession of the home. You don't deal with support or parental rights and responsibilities. So then I move into, would you get a dating protection order or a civil stalking protection order? If you're considering a civil stalking, it has to be in common pleas. You need to show a pattern of conduct. If you're considering a dating relationship, you go into domestic relations court. The relationship is of a romantic or intimate nature, but you may have to prove those facts, which a court may believe a dating relationship took place. And often that means, is there a sexual relationship? And if you don't want to prove your sexual relationship, then you consider a civil stalking order. Then we have juvenile protection orders, same thing. It's not a criminal proceeding, it's civil. It's not depending on any criminal case. It applies to all juvenile respondents. So I can be an old woman who's asking for a protection order against somebody under the age of 18, I must go into juvenile court to get my protection order. I could be a 13-year-old girl against a boy who is 16, must be in juvenile court. Everything does not depend on the age of the petitioner. It only depends on the age of the respondent. Unfortunately, the focus is not on teen petitioners, although some are. And juvenile court has exclusive jurisdiction to both issue and to enforce juvenile protection orders. And then we have no contact orders. These are creatures now of the Supreme Court. Oftentimes, as part of a criminal case, the court says you can have no contact with the victim, but nothing is given to that victim. That victim in criminal court is being told he's to have no contact with her, but they are not given anything. If it's violated, you can't call the police. You must go back to criminal court, talk to the prosecutor, talk to the probation, and they may violate his bail and put him in jail until the criminal case. But these no contact orders are also issued after the criminal case is over as a term of probation. What we've learned is these protection orders, there is a potential duty to arrest. A law enforcement officer can arrest a person in violation of a community control sanction. In this case, it would be being with somebody, being around somebody, being at their home, being within a certain amount of feet from them. These no contact orders, the Supreme Court created forms for. They are considered protection orders for purposes of entry into NCIC, which is the national database, like all protection orders are entered, and police may be able to enforce them. If they do, they can arrest them. They have to call the issuing court and they say, hey, I've got your person. Do you want him? If the issuing court and probation says no, then they'll be let go, or they can pick them up and then it can be a probation violation in the issuing court. So with that, I've given you a little bit of the landscape. I've not, there's so much more, but I thought I would end with this and thank you for all you do. And I hope there are some questions. I guess the last thing I did want to say is about legal aid. We deal with civil problems. That means what we deal with child and family, that's domestic violence, divorce, civil protection orders. We deal with child support. We deal with healthcare, Medicaid, Medicare, public benefits. We deal with housing. We do eviction defenses, foreclosure defenses, some landlord retaliation if somebody is locked out of their home, and some utility issues. We deal with money issues. For certain people, we provide bankruptcies. We also seal many criminal records. Sometimes we deal with income tax problems for victims, unemployment appeals, and other civil legal assistance. We work with immigrants and trying to help them remain in the country, depending on if they have come here legally. We don't help with any criminal matters. The closest we get to the criminal matter is sealing certain criminal records. If somebody you know or you need help, you can apply online by visiting Legal Aid's website, which is lasclev.org, and click Apply for Help. Or you can call 1-888-817-3777, and there will be interpreters provided for that. Or, depending on the day, time, you can walk in. We're usually open Monday through Friday from 9 to 5, and that's it. Or you could be referred by somebody who may be able to take your case. Thank you, and thank you for listening. Cheyenne? Are there any questions?